From Shihab Burke Law Firm, Monday at 6 o'clock. We're going to be having a great session today. 1 hour of Q&A or until the questions, all of them are answered, whichever occurs first in time,
Yeah.
Brian. I'm Sam Shihab.
I am Brian Burke, and you spoiled it for everybody by calling me Brian without allowing me to announce it. And how about it, Sam? We guess we can get right to it?
Yes. But before we do that, how was the weekend? How was your weekend?
Well, I saw you a little bit more than I would on an average weekend. Maybe we'll bump into each other on the office on a...
So we haven't done this in a long time.
Yeah.
And we set up shop at the Central Ohio
FIA India Festival,
India
right?
Festival, yes. We used to do that a while back, and we kind of got busy. But we kind of felt like we want to do something this year, and it was wonderful. I really, really enjoyed it.
It was a fun day. I told people that when I was done, I ate a bunch of food, and I told people.
I saw that.
Yes, you did. You had a front row seat on it. And I told people that when I was done, the next day I'm gonna run 5 miles and mow the lawn to bring a balance to the universe. Turned out I was exhausted. I ran no miles and mowed no lawn.
What ended the day stuff?
But I was hoarse all Sunday, but I'm feeling back up to speed now, and I didn't go out and get running.
That's why I did my workout before I came in.
Yeah.
No,
well,
sorry about that.
No, that's okay.
But we did see some of our listeners there,
Oh, yeah.
and we met some good old friends, people we haven't seen because we're just stuck in our offices, pushing paper and talking to people on the phone.
The last few years have been weird due to COVID as well, but we've been trying to sort of shake all that stuff off, and that's why we're here doing this YouTube thing too. Just going out more into the world like we should be.
Yes. So we had a great time, and we figured Q&A would be in order. And we have about 5 questions that came through the Indian Festival, but we are going to take them whenever there is we'll probably take one at a time. And let's jump in answering people's questions because people have questions.
Shall I start with the questions that people have in the
Yeah.
audience here?
Yeah.
Okay.
And then we'll just jump to these, give
as
people
we
more
need to.
time. Yeah.
So here we go, starting right here on screen.
And if you make that bigger,
I will make
Brian?
that bigger because even I can't read that one. I would, not with these big glasses even. From Din S. I got laid off on August 2nd, 2023. So my question is, can H1B work an H1B receipt for a new employer without going out of the country and come back if I filed for Compelling Circumstances EAD? A good question. So just by filing for the Compelling Circumstances EAD, for me that's not a problem. The problem that we've discussed in the past with the Compelling Circumstances EAD is that by using it, you are out of status. You are conceding the point that you cannot maintain your status.
It's not a bad out of status, but it's not mean that it's a big bad thing.
Yeah, you're not accruing unlawful presence in the United States, but just by applying for it, it's not problematic. So,
but using it is.
Yeah, using it's not even problematic. It's sort of contemplated that you'll eventually
It takes
leave.
you out of the H1B.
Yeah, it's sort of contemplated though that you'll eventually leave and come back to get in status.
It's probably one of the stupidest laws there is. I mean, let's be honest. Why can you not get in and out of status?
Yeah.
It makes absolutely no sense.
Yeah, the rule being you must be in status to get status, and that's the problem with this hypothetical scenario. The DNS uses this EAD.
With very few exceptions. With very few exceptions. So you have assuming you have a valid I-94 for some time, I hope, you get a grace period of 60 days maximum, or until the I-94 expires, and you hope to be able to get a job during that time. And remember, USCIS kind of encourage people that if you're not really finding a job, go ahead and apply for a B visa.
Yeah, that's we're sitting here and grouse a lot about the bad things that USCIS does. They're slow, that sort of thing. That's something that's pretty darn nice. Folks who aren't aware, they said, hey, if you're running out of time, apply for a B visa. And if you apply once you file for a B, you're out of the grace period, you file an H1B to change back, we'll approve that, and we'll give you an I-94, and we'll basically approve the B at the same time, which is huge. It's essentially...
So basically, it took that 60-day grace period and made it 1 year.
Yeah. Really, it's absolutely crazy, insane. It's awesome. It's something I rarely get to say, but you know, I don't know how long that policy will stay around, but it's a great one to have.
Yeah, the USCIS is recognizing that we've lost a significant number of foreign talent in the last 3 to 4 years, and I was sharing some of the information I was researching the other day. I think we've lost over 200,000.
Yeah.
Going back home to Canada and to other places in the last 3 years or so, and that's a serious loss. So I think they're trying to keep people. Let's take the next one.
Yeah.
Hello, Sam and Brian. My employer is filing an H1B amendment for my role change. Do you think H4 and H4 EAD will require an amendment? The first question. I-94, H1B, H4, H4 EAD valid until September 2026. Stamped visa expired for both. So there's only one question.
Yeah.
And the answer is absolutely you do not have to file for a new H4 or an H4 EAD since these are valid until 2026.
Yeah.
So that's wonderful. Leave those alone. And now we always try to kind of harmonize the H4 and the H1B together so they expire on the same day.
Yeah, yeah.
So would you recommend something like this with the 2026 date?
Well, it depends upon the nature of the amendment that the employer is doing. So if an employer is doing an amend extend, which they might choose to do, it would suddenly put an individual's H1B I-94 valid for a new 3 years, presumably if they do a full 3-year extension. Whereas the rest of the family would only go until September 2026. And what happens?
September 2026?
Yeah, I realize.
Almost 3 years.
Yeah, 3 years. That's more than 3 years,
3 years and 1 month,
from today.
No sense.
But I'll take the hypothetical anyway and answer the question. We always encourage people to keep their H4s and H1Bs in sync because when they don't, you run the risk of forgetting about the H4s to extend them. And it puts people out of status and it requires attorneys like us to file, nunc-pro-tunc filings or just give people the sad advice that, you can save your immigration status by leaving the country and coming back, and you'll probably be questioned about, hey, how did you violate your status, by the consulate when you come back.
So you would recommend extending it even though it's valid for 3 years almost?
Well, I would recommend, this scenario is interesting and we don't have all the facts here, but I would always recommend trying to keep those dates in sync because
as a general rule.
It's a pretty common occurrence that something we see.
Got it.
Yeah.
Okay. All right, so moving on to the next one, Brian, for you.
Ooh, a great one. Would you recommend traveling on an E2 visa with an approved I-140 petition on file, considering the concept of dual intent? I would say that first, let's start with the concept of dual intent. A lot of people in our audience, just like one of the last question asker, are on H1B status. And when you're on H1B status, you and a couple other statuses, like, for example, you're allowed to have dual. You're allowed to intend to immigrate, and you are, stay in the U.S. on a permanent basis, as well as maintain your non-immigrant H1B status. Perfectly happy to allow you to do that. The U.S. government is. E2 visas come with a requirement that you have no immigrant intent. I would bet that this person here, when they applied for an E2 visa, they actually had to submit a letter to the U.S. government in one way or another saying, hey, I understand that when my time on E-status is done, I'm going to be leaving the country. So that's the concept of dual intent. And to make the answer simple, no, I would not recommend that travel. It's not 100%. USCIS doesn't have a policy out there, to my knowledge, saying whether or not that I-140 is considered evidence of your intent. But I'd say you run a risk.
I would be curious, Mr. Harrison, because if he's Canadian, for example, I can tell you that I have seen it at the border where they look up the I-140.
Yeah.
And they'll say, no, we can't let you go. Show me evidence that you withdrew it.
Yeah. There you go.
Yeah. Now, it's not something I'm recommending, but you can always withdraw, and then the circumstances changes, refile.
Yeah, I mean, depending upon where you're from, this situation might resolve itself if you have an I-140 petition on file. If it's been approved, if you're not from a backlog country like India or China, odds are that I-140 priority date is going to come up soon, October perhaps, and then suddenly you would be able to resolve this issue by filing an I-485. However, it doesn't resolve your issue by filing that I-485 because you'll still want to be able to travel, and you won't be able to travel until you have an advanced parole, and that advanced parole is taking a year. So
again, I'm sorry to be critical today. I think that's another dumb rule.
Advanced parole rule?
No, the I-140.
Yeah.
Immigrant intent, not signed by the beneficiary.
Yeah.
How in the heck that's their intent? There's nothing on paper that they declared an intent up to this point.
Yeah. Okay. And I'm gonna be the customs officer. So okay, you didn't sign off on the I-140. So what were you doing? You just saying no, please don't file an I-140 for me.
Well, no, I agree with you. It's a dumb rule.
Yeah.
I'm saying it's a stupid rule. It's
Yeah.
not a smart rule because there's nothing that the beneficiary signed to declare an intent.
Well,
They should not prevent people based on I-140 filing. It should be based on I-45 only.
I agree with you. It should.
You
but
agree? I like that.
It should, but as a practical matter, guy who's at the border here, and I'm about to turn away because you fought against.
You're not gonna. If
you fought against that I-140 filing? Was that I-140 done for you under duress?
Yes.
Did they include any of your personal information in that I-140 filing, my friend?
how do you know?
Well, I'm a customs officer, and I can see a copy of your file right here. Well, it says it has your name and address there. Is that your name and address? Well, how did this company get that?
Well, I'm not talking about the company officer, Mr. Bryan.
Yeah.
I'm talking about the law.
You address me as Officer Brian. Thank you. Yes.
Yeah. The law is not very smart on
Well,
this question.
Yeah. I would agree. Yeah. I mean, I don't like having to tell people about these wacky scenarios like, oh yeah, just to let you know, you're going to enter in a blackout period where you're not going to be able to travel for a long time until the government coughs up an AP for you. That is a lousy scenario. Yeah.
Yes. All right. My priority date is March 2012. I switched jobs, so couldn't file my 485 when dates are current. Unfortunately, my current employer started my green card process 1 month ago. I couldn't get promotion since green card is pending.
Let's see if there's a part 2 here. There is.
When can I get promoted without the need to restart the green card process again? Promotion wouldn't change many of the responsibilities, just grade level and pay. Well, that is something here is not adding up with this question, in my opinion.
Okay.
Because the green card application normally is a future application.
Yeah. For what?
And therefore, if there is any proper planning in the drafting of the job description for the labor certification, you would not put the current job. You would put the future job. What is the job will be, depends on your country. 3 years from now, 4 years from now, 5 years from now, or so.
Yeah.
So it looks like the job may have been drafted to copy the current job, which got this guy a little bit in a tough spot.
Yeah.
The promotion, the problem with the promotion is that during the labor certification is problematic. After the labor certification, you can probably argue it.
Well, so here's my problem I have with the promotion. So so you're probably thinking way out in front, like portability, supplement J, same or similar occupation, and they say in their policy that same or similar occupation can be with the same company, right?
But not when you're filing the labor certification.
Well, I mean, so the labor certification and the I-140, and ultimately, filing I-485, that's your company and you agreeing, this is the job I'm going to take, and I'm going to accept that job. Agreed, and that's when you send that file. That's the problem I have. You can't get to the if the job is not what you. I guess here's the scenario is this.
When can he get his promotion?
If they're able to file his I-485 in good faith, he can saying this is the job we're going to give him, and he's willing to take it. After 180 days. The portability.
So not during the labor certification process?
No.
Because it appears that the job description described the current job, not his future job.
Yeah.
If the labor certification described his future job, as it shouldn't describe today's job. When you're doing a labor certification, you need to say, what will you be doing 3 or 4 years from now?
Yeah. Yeah, that's a bare minimum because that's honestly the amount of time it takes to get a green card. Let's think of it: 2 years for a labor certification, about another year and a half for an I-45.
Like if there's a supervisory responsibility, et cetera, et cetera, et cetera.
Usually one of the things we'll talk about with clients at the beginning of this thing, well, this process is going to take a while. So if you're seeing this person move up into your company,
in the next 2 to 3 years, at least survive the I-140.
Yeah.
You know what I mean?
Yeah.
Beyond that, you can probably argue it that, I cannot be sitting in the same job at the same time and now same or similar job classification potentially.
Yeah, well, I mean, guess the alternative right now, if this is a job that somebody's willing, if whatever job is, maybe not what you like to have in the future, it's always possible to go through the labor certification process again. I mean, this case, per the prior note, it was I'm 21 months in. I imagine somebody's very close to getting an approved I-140 at this point. I mean, about 9 months for maybe more like 6 months now. Prevailing wage times seem to be coming down a little bit. Plus 9 months, actually, but the perm processing times are going up. I mean, you're probably really close to perm certification at this point, I would guess. And you can do it again, I guess, in the future is the point I was trying to make.
What do you tell people who have a priority date of 2021 in a 2012 visa bulletin date? So they're not going to file their I-485 for a decade. So they get the labor certification filed, and you file the I-140.
Yeah.
Now, 10 years later, you're going to say, I'm holding the same job?
For some people, I mean, it's an issue that's come up before. I remember a couple years ago, a company had a guy who was, he was like a junior, not a junior guy, but just a mid-level computer programmer when we did his green card. And, about 10, maybe 9 years later, I said, looking at his H1B, I said, wow, he is like now the vice president of something, vice president of software or something like that. And you may want to consider revisiting this because the priority date's coming up soon. And they eventually did revisit it, and now he applied for an I-485.
What about a programmer or a systems analyst, and now lead system analyst?
It's not really 100% clear, but I think you can make an argument that it's substantially the same job. I think the question I would ask, I would tell the employer, you have to sign off that you're still willing to give the job that's in this labor certification. The employee has to be willing to take it. Can you sign off on that in good faith? Saying it's is it really? It's pretty much the same thing. Is the question? How
can it be the same after 10 years, Brian?
For us, sometimes it's not practical.
It's a problem, yeah. So there is a.
I think we've hit another really stupid hole in the law then.
Well, yeah, I mean, there is a disconnect between a 10-year wait and then filing an adjustment of status saying the labor certification that was filed 10 years ago is my job. And there is an accommodation, I think, by USCIS, although it's not typed up or written up, that if it's the same line and it's not a significant change, I mean, you're not a director of the company. If you're a director of the company, or you're taking on a completely different role, you need a new labor certification. Yeah. But if you're going
exactly
from
like
to a lead position, well, that's a normal progression within. Most likely that's okay. They're not going to make a big deal because of the AC21 rule, because it accepts same or similar after the I-485. So if the priority date is retrogressed for 10 years.
I have wondered this. I've gone to plenty of green cards interviews with people where their labor certification is quite old, and USCIS basically are you still if you're a an IT consultant? Are you still an IT consultant? They're probably not going to be really inquiring much beyond that. Yeah. Splitting hairs about what you're doing now versus what you're doing now.
Back to 1308 Nani.
Yeah.
The answer for him, in my opinion, depends on how the job description is drafted and what is the promotion going to have you do. But you indicated it's pretty much similar. Well, how much similar becomes the question, and that's really to answer your question whether you can get a promotion or not, and how quick are you going to get your I-140. But you not get a promotion for 10 years if you're born in India. Yeah. That would be ridiculous.
That would be ridiculous. I guess I would say, if everybody in this scenario here, all the attorneys, all the company, and you agree a new labor certification is needed, it can be started now. You don't have to wait until the current one is done. It's going to take. There's certain issues that come up when you have multiple in process, which they don't typically like, but you can start the process now.
Yeah. All right. So, do you guys anticipate third H1B lottery for this year? I I think it was October 1st or something is the filing date?
October 2nd, I think, but yeah.
October 2nd?
Yeah, I think so.
So right now we see things moving slowly, in my opinion, in terms of the, the 77,000 that they have selected. We're not seeing companies jumping on them. I think companies...
they always wait a little bit.
They do wait a little bit. So it's hard to answer the question not knowing what's going to happen. If the economy does a soft landing and looks like things are looking good, everybody's using up, then there will not be. But if there is a...
So I guess USCIS, when they did the second round, they selected, what was it, 77,000? That's a ton of people. That's almost an entire H1B cap's worth. And the net number they selected was probably likely to try, it was based upon the data from the first round. They said they got a 40, or it was about a 40%, or the numbers reflected about a
45% or something.
45, somewhere around there. Approval rate, meaning they anticipate that in the next round, and they took enough such that even if we get an abysmally low 45%, from registration to approval rate, that we'll have enough to get it. So I think they're trying to avoid it, but again, there's factors that might not have considered.
I would agree with you that the number reflects that they really don't want to go through a third selection.
Yeah.
That's how I feel, but it's hard to tell until we see how many applications. It's simple math. How many people applied? So that is a question that is going to be based on the future, and I cannot tell the future.
Yeah.
All right, sounds good. Appreciate your time. Your channel is so underrated. Well, thank you, 130890. Well,
I've heard that a couple times, and I appreciate it.
We appreciate whoever comes here. We're not looking.
Yeah, I want to know who's rating channels though. I want to find the guy who's making meta YouTube videos about us, just giving us rankings.
Yeah. So, shall we take a couple of our questions and allow people to come in and ask questions here? There's a couple of them here.
Yeah, we have. I think we have a decent crap here.
Let's keep it going. We'll hold these up because these are good questions that were asked.
Yeah.
We can.
Hey, another good one coming up here. Is severance package considered a bonus to grace period when employer fired H1B employee?
Wow, all those great questions.
Yeah.
All those great questions. Here's my answer, and your answer may be different. In general, we see USCIS, at least this USCIS, will lean in favor of that, but don't count on it. They look at the last paycheck and they will consider you employed until that time as a matter of oversimplification for them.
I would fully agree with that.
They give you the benefit of the doubt on that front.
What are you going to make me do the second half of this? The but or
however?
Yeah. However, Sam and I have had recently some very intense discussions on the nature of the H1B grace period, and we've read the regulation pretty clearly, and it talks about a cessation of employment. And when your employment ceases, your employment ceases. And I think the conservative way to approach it, and how I think it probably is intended to work, is 60 days from your last date of employment with the company.
Yeah, so if they take a conservative approach, it's going to be the termination notice or the termination letter, in which it will tell you
for a letter confirming your dates of employment,
in which your benefit cease to exist per company policy, and maybe your health care is switched to a COBRA. I mean, so there's all kind of solid, bright line that USCIS can point to and say, that's day 0 in your grace period, and then start counting, even though there's a check coming down the road. But we've seen success in arguing that check is the termination of employment, and they just don't push
I guess
back.
I would say is I haven't seen. I mean, we tend to approach it, pretty conservatively, and most people are aware of what the deadlines are, and I haven't seen questions about whether we don't think you're in the 60 day. I can't recall an RFE on the subject of we don't think you're in the 60-day grace period. And that's that. Usually you don't even have to really explain it to them anymore. They're aware of it, and very little scrutiny on the fact.
And given the fact that you can switch to a B visa, visitor visa, and they give you the hint that, hey, you're running out of time, just file a B visa and practically extend your grace period to a 1 year.
Yeah, that's so cool.
It's very
And
we are going to work with you on that, means that they really want to give you the benefit of the doubt. And I wouldn't rely on that check date.
Yeah.
I would file a B visa anyways.
Yeah.
And I would argue the check date, but I have a fallback plan, which is the day, you know, the B visa change of status.
It can be done on you know, quick
the
notice.
same day.
Yeah.
Easy to do.
I wouldn't recommend doing it on the same day, but you can do it, you know, in a pinch. Whereas
I wouldn't recommend doing it on the last day.
Yeah, definitely not. That's yeah.
That's a good question, though, from Din S.
Yes. Sriva, have EB3 and EB2 EADs. EADs expire in 1 year, and EB2 EAD expires in 1 year. EB3 EAD in 5 months. Am I eligible to renew now, or do I have to wait 6 more months when the EB2 EAD is about to expire in 6 months? So, I guess I want to pick up, you know, one of the questions we got. You know, people generally ask us like how things are going in immigration. One of the questions that, you know, we had gotten previously was, hey, what are the trends in adjustment of status matters? And one of them that we were seeing for a while is that USCIS saying, you're not entitled to 2 EADs at once. We're going to close one of these out administratively. And that's when I guess I would point out, you know, EADs are tied to your adjustment of status. They're not really tied to a category, any category whatsoever. So I guess what you could say is you don't really need to have 2 EADs.
But I'd like to, Brian.
I'd love to, yes.
And I disagree with USCIS. Again, I'm sorry.
I fully disagree with USCIS.
I'm sorry to...
we were nice to them. We gave them the benefit of the B2 policy.
Well, no, they collected 2 fees. They collected 2 fees for 2 adjustments. That's number one. There is no law that says you cannot have both.
I know.
There is absolutely no law. There's no law that says you cannot have them. There's no law that says you can. But they took your money twice legally. You're entitled to the benefit of each one.
Derivative benefit from having a pending I-45 and 2 pending I-45s. Yeah.
The problem, obviously, is they're doing these EADs for free, and they want to save money, so they come out with, you know, USCIS is known to create law out of thin air. And they like to do that. So they just create this policy out of thin air without any support.
Yeah. So,
but I would file the
EB3. I would file, yeah, now, definitely. And I would...
and then I'll file again.
I would only include a record of the of the EB3 EAD that's soon to expire, just so they don't, you know, if they have the information, they might be inclined to go, why am I doing this, you know?
Well, yeah, absolutely.
Well, you got to be thoughtful about the documents you put in.
Well, it's legal what you're asking for, and the fact that the right hand doesn't know what the left hand is doing at USCIS on a more frequent basis than not, take advantage of that.
Yeah, sure. Oh, part 2. I think we already answered it. Is there any USCIS rule that says to apply for renewal when later one expires in less than 6 months? So, no. From Ram.
All right. Hi, Sam. How to utilize H1B cap approved petition if I did not use it for 6 years and I did not stamp with employer? Well, Ram, unfortunately, you are cap subject. It goes and get allocated for the next year numbers, and that number, that cap, is not subject to you because you did not stamp. And I'm assuming, I'm making one assumption here, which I don't think,
get 994.
I don't think it's an assumption, that you did not get I-94, which is implicit in the statement here, but we don't know. So if you did not get an I-94, did not work as an H-1B worker, did not receive an H-1B stamp, but only selected in the cap sometime in the past, you are still H-1B cap subject.
I agree with you.
However,
I think this is a scenario where USCIS might be willing to approve a case where there's how the law reads and how it reads to us really clearly, I might add, and how they interpret it is another bag of beans. And this is a scenario where I would say it's an H-1B case you could consider filing, and they may raise this issue. But if that H-1B is approved, how does USCIS know to put the, if you know you have a 3-year approval period, Sam, you know, how does USCIS know to put that number back in the pot? Do they keep track of that?
Oh, from a practical standpoint?
Yeah.
Oh, absolutely they don't.
Yeah.
But maybe they do.
I think this case might have some legs. It's a risk for the employer that's filing it, I think.
Well, correct me if I'm wrong,
Yeah.
but I think what you're saying is it has a potential.
Yeah.
It is not something that's guaranteed.
Oh, definitely not. No, I can't guarantee. I have been asked about this similar scenario.
And it's not strictly in accordance of
The way
our
the law-
interpretation of USCIS regulations.
Yeah.
That would be a fair statement.
Oh, definitely so.
However, we have seen
Similar scenarios work
similar
out.
scenarios work out. However, there's two things here I would add.
Yeah.
USCIS is more likely to approve or kind of look the other way on more recent
I agree.
H1Bs.
Yeah.
So if you walk in with a 2019 or 2018 H1B cap, I would say you will get pushback
I would
that
basically.
you haven't used.
Employers sometimes ask about this, and I say, this is the sort of thing where you could go forward with it, understanding the risk. Then they may raise this issue, and your money's lost, and the case is done.
But we've seen it work sometimes. I agree.
From Army, any thoughts on the possible final action date for EB3 Philippines this October 2023? So, dates for filing. Well, I'm going to go back a page. Let's start with the dates for filing. So, Philippines, EB3 is, dates for filing for September 2023 is in 1st of May 2023. And basically, for those who aren't aware, dates for filing are supposed to be a future look for the final action dates, meaning as long as these dates for filing are honest in what they're supposed to be, I would say it's not so crazy that EB3 for Philippines could reach its way back to May 1st, 2023 in the next fiscal year. October, I don't know, but maybe sometime in the course of the next fiscal year.
So no one knows about how sausage is made, and no one knows how the visa bulletin dates come out, and we speculate and calculate, and then we're off and wrong, so then we're right. I want to say that the only reason Philippines and Mexico are on this chart, dates for filing in their employment base, is because they were split up in the family-based because of the backlog.
Yeah.
And there's no other reason for them to
the numbers for those countries typically mirror the rest of the world for employment base.
yes, and you can look at that. There's absolutely no difference.
Yeah.
So you need to treat the Philippines as all chargeability area, and the rules and the logic, the analysis at least, applies to the Philippines same as all chargeability areas in the employment base. And we were speculating that it has a good chance of it to become current.
Well,
May 2023.
that's
4 or 5 months.
from where it's on May of, well, it's on May. Final action date is on May of 2020, and May of 2023 is where the dates are filing at. I think it could be a nice big jump.
So it could be that the final action date may jump to May 2023, and it could be that the dates for filing becomes current.
Yeah,
very possibly, because
while I'm here, I may as well pull up the I-140 data that's been so useful. I'm not going to bother putting it on the screen for everybody, but I'm going to look at the employment-based third backlog for the Philippines as of March of 2023. And
it's significant, as a matter of fact.
well, it's significant, but 2,100 isn't that enough?
But isn't the worldwide? What's the world number?
The rest of the world.
The rest of the world.
11,829.
So that's a significant number.
But Philippines is what's the allocation per country?
7% of the total 2,800. I think.
Yeah, for EB3 though, what does that calculate out to?
4,000 to 5,000 is the number.
Well, and as of March 2023, there are only 2,100 in the Philippines backlog, and obviously that more have been added since then. But it seems to be primed for a pretty good jump.
Yes, absolutely.
Yeah.
But I am still surprised that it represents a significant percentage of the worldwide.
Yeah, it's
a chunk.
Yeah, it's. I mean, the rest of the world has 11,829.
Philippines
has 2,000. Now Mexico, Sam, has 4,000.
Has even more, and they're treated exactly the same. So far, yeah, exactly. So I guess so far so good. I think we stand behind the prediction that the final action date will probably move to May 2023. And the filing date could become current.
If we have to go based upon the data we have, the dates for filing is the data we have, and fortunately, October 2023 visa bulletin is dangerously close. I mean, sometimes they release those first visa bulletins as they did late in the month, enough to get us to pull our hair out.
They will not do it this year because always it takes them a while. Remember, there's a new trend that they're delayed on those
on the important visa bulletins come late in the month. Yeah.
All right, good question. Yeah. So moving right along.
Yeah.
From a T.
Yeah.
I filed for adjustment of status under EB2 India last year. Okay, good. My priority date is 2013. My EB1A I-140 was approved a few days ago. Congratulations. When the dates become current, am I better off filing a TUB under no 485J for a new 485 or a new 485 under EB1A? Well, clearly you're not going to go anywhere with the EB2 2013 priority date, and second adjustment of status is maybe a waste of money. I mean that.
Well, yeah, he can't file a second adjustment of status now anyway.
Until it's current. Until it becomes
current. He can't do a tub right now.
When it becomes current, he's
saying.
Yeah.
Okay.
He's saying when dates become current. He's very aware. What shall I do? Shall I file for a transfer underlying basis, or shall I file a brand new I-485?
That is tough, Sam. You know.
It's not tough for me.
Yeah.
The EB2 is not going anywhere. 2013.
That's a good point. Yeah.
Yeah. I mean, I would usually say file a second one, but here. That 2013 is not going to get you a green card. The EB1 is going to get you the green card faster.
I think the question though is, am I going to get a green card faster by doing the TUB or filing a new green card out? What process is going to move faster?
Well,
and that's where I find it to be a hard question.
I still don't, because the question is, which is better for me? Just to make it very broad.
Yeah.
What is better for me under all the circumstances? The 2013 EB2 India is not going anywhere for quite some time.
Yeah.
That baby is stuck.
Yeah, so there's no sense writing on that, leaving that EB2 case writing because why would you? Because but so if I file that TUB, it's a race. It's a question of a race though. If I set these beasts a TUB versus a second filing, I think his fundamental question is which one is going to get approved faster, and.
I think the TUB will be approved faster.
I am inclined to. Nobody knows, because here's one thing, Sam. In what is it, early 2022, we saw some very quickly approved second I-485s as well, like in a couple months. But I think that's more of a fluke. What is the stated processing time on an I-485? It's measured in
18 months.
Yeah, over a year. And if USCIS wants to put your new case at the bottom of the pile, they can say, "I'm sorry, it's only been in process for a month." You don't have that problem with a TUB.
And also, I want to preface what we're saying with advising a T that ask me that question when you're ready to file, when the dates become current. I'd like to look at the dates at that time.
Yeah, that's very true.
To advise better.
If you're current in both categories.
Yeah, if I'm sitting right here, that's my answer, but I may be giving you a different answer later on.
Yeah.
All right, sounds good. Congratulations, Ati, for the I-140 EB1 approval.
Yeah, it's great.
Yep.
So,
Joe Harrison.
Yes, would appreciate your take on the EB2 Rest of the World progression for fiscal year 2024. Do you think the category will become current again anytime soon? Well, I can't help but look at the rest of the world.
So Joe Harrison is the gentleman who had his E2 visa?
Yes. Yeah.
And
he needs that priority date to become current so he can file for an I-485 so he can travel. Yeah.
He wants to go home to see cousins and mom and dad.
Well, I mean, he has a problem though. He won't be able to, one thing you explained that he has a problem potentially traveling, and he also has a problem potentially extending his E2 visa status as well. So I hope he has lots of time left on his I-94.
But always remember that if you're I-140 based on a labor certification, you can easily withdraw that and refile it.
That's such a good point. That is a good point. Yeah.
And you don't lose anything.
Yeah.
So that's an
emergency needs scenario. Yeah. Well, so EB2 Rest of the World. I'm going to look at that chart that I have up here on the side again. has, rest of the world as of March 2023, and I'm curious if the new data is out on this yet, but had a backlog of EB2 5,475, and that's spread across, however many countries there are in the world, 100 some. Obviously, some have more than others. It seems feasible that it could become current again in the coming fiscal year.
We've probably almost the same question as the Philippines.
Yeah,
if we're treating the Philippines same as the rest of the world as we decided that we are.
Yeah.
And we thought that the filing date most likely will become current, but not the final action date, because the final action date is right now for EB2 rest of the world is July 2022.
Yeah, but I think it's more like it seems like it's more possible for the rest of the world to move, because the rest of the world has 7% for a ton of countries, and and the Philippines just has 7%. Don't get me started.
But the ratios are disproportionate.
Yeah.
The Philippines has 2,000 out of 19,000.
Well, yeah, but
although he doesn't care about the Philippines, he cares about the rest of the world. So 19,000 right now, that number is growing.
Yeah.
So I would say you have a decent chance of it current. I mean, it's hard to tell.
5,000 EB2s from the rest of the world versus 5,475 as of March 2020 for the rest of the world versus, the 11,000 from the Philippines.
I'd say reasonable chance.
Yeah.
Yeah, but it's hard to kind of predict beyond, honestly.
Yeah, well,
stay tuned. It's coming up soon.
We're Sam. I think as soon as that visa bulletin comes out, I have a sneaking suspicion that our YouTube topic will be the October visa bulletin, and we will talk and we will talk and we will talk about it. Yeah.
You don't say.
What?
Is that right?
Yes.
You're gonna have the July visa bulletin?
No.
I'm surprised.
October visa bulletin.
October visa. I'm surprised.
Yeah.
Are we gonna?
I think we're gonna do a YouTube about October visa bulletin. I think we just might.
We will.
Suresh.
Go ahead, Brian.
Do you have an update on visa stamp inside the USA? When do you think it will happen?
Are you kidding me? Absolutely. If it doesn't happen, it will be such a bad thing, because they promised to do it this year.
Yeah, is that when it was?
Itself.
Oh, we're running out of this. Oh, they said they're going to do a pilot of it this year. So I imagine just like one guy, he gets an email from the Department of State saying, "Congratulations, you're the one guy," and that's it. Pilot program completed.
This year itself.
If your pilot program is small enough, Sam, it's very easy to get your pilot program completed. It can be a bespoke artisanal pilot program completed on behalf of one person, and the government can pat itself on the back.
We don't have any updates, Suresh. Brian is being sarcastic.
Yeah. Well, the last we heard was as part of Prime Minister Modi's visit from India. It was something that came up as on the.
Well, Modi himself delivered the news to everybody that this year itself, he said.
Well, it's part of that joint statement. A statement from the. Well, that's where I recall reading it. I don't know if you.
He had a speech to. He had a conference. He went.
Here are the results I delivered. Yeah. Okay.
He just told them that your H1B will be renewed this year. So, and obviously he wouldn't say anything like that unless he was promised by the State Department that go ahead and say that. We will back you up.
It's not in the good interest of international politics to make a foreign leader look like a fool.
Exactly. So we'll see here. And Biden is very sensitive to these things. Yeah. So we'll see what happens. But we don't have a better information for Suresh. My priority date. This is from Nepal 123. My priority date is March 15, 2023. Rest of the world. Do you think that I should make an appointment for medical soon, given that USCIS now accept medical within 2 years of doctors signing the form? March 2023.
March 15th, 2023, rest of the world. So
I would make a medical appointment now. Probably, yes. And I would time it such that you can cancel it if the visa bulletin comes out not favorable. I mean, call and find out how quick can you make an appointment. If they make it within 1 week, I would slow down a little bit, because I don't want you to do a medical and not use it.
Well, I mean, it's still good. It's still good for 2 years, and I would hope that he would have a green card within 2 years.
So you think you're a little bit more optimistic than me?
Well, I think anybody's motivation who's in our audience is probably get my green card as fast as I can, and if I can take a slight risk that my risk that I'll need to get another medical exam.
I like,
can get one
I like
now.
your answer.
Yeah.
I like your answer, Brian. Good. All right. Brian, take that one.
From Emily, with the retrogression for most EB categories because the visa has basically finished for this fiscal year, do you guys see any faster processing of EAD or approval of AOS cases? No.
Yeah.
Usually, Sam, I like to give a long-winded, nuanced answer. No.
Yeah.
You know, one thing I got a little bit of long wind. One thing USCIS was doing was sending cases, employment-based adjustments to local field offices for them to be approved there. I don't foresee them doing that with EADs or APs or, yeah.
All right. Scooby-Doo. Like the name. If the green card is through employment base and married to a U.S. citizen after, an individual can file N-400 just after 3 years instead of 5 years. Wait a minute. Yes.
Yeah.
So if you got your green card through employment and then you got married to a U.S. citizen shortly thereafter, the 5 years is waived because you're married to a U.S. citizen. Yeah. You don't have to get the green card through the marriage to get the 3-year waiver.
The standard is physically residing with a U.S. citizen spouse for 3 years, not having gotten
the marriage,
the green card through it.
and physically living together, by the way.
Yeah.
If you're married and separated, then you don't get that. You don't get the 3-year benefit.
Yeah.
Yes.
Okay.
You have to be married for 3 years, and your U.S. citizen wife has to be happy with you at that time.
They will investigate those things if they don't think you're living together. Yeah.
Oh yeah. It's a big deal. I mean, even if the marriage is still there, but you're not, you're kind of separated. That's not good. Yeah. But I'm sure Scooby-Doo is happily married.
Yeah.
Emily Marshall, Brian.
Any opinions on why the date for filing for EB3 India is still 2012 for the last 2 visa bulletins, even though the dates for retrogress so significantly? Maybe it's just talking about the
why? Yeah.
The date for filing is still in 2012 when the final action dates, I presume, are in 2009.
So let's look at the dates. I think we may have an answer, but.
So EB3 India, I presume she's talking about, dates for filing EB3 India are in for September 2023 and August of 2012, whereas the final action dates are in January 2009. How can they be so far off? And I guess my answer would be, based upon what the government, I'm going to look right here, the EB3 backlog. No, that's impossible. The EB3 backlog, as of people waiting for visas, this is I-140s waiting for visas though, as of March of 2020.
So it's the end of the fiscal year.
Yeah.
So you have EB3 is 2009, right?
Mm-hmm.
And that's final action date. And dates for filing is August 2012.
Yeah.
And why is that big of a gap?
Yeah.
Well, we don't have a reason why, but we have an potential interpretation as to why. And it is because I believe that there is a feeling by the State Department that the dates are going to significantly move on October. They're holding it back because they ran out of visas, because this is the last, January 1st, 2009 is the last available case that they do not want to approve. So they move it back to that date. If somebody
stop them from approving,
and to stop them from approving cases, but they believe that once more numbers are available, that the numbers are going to may jump forward to
sometime in the near future, August of 2012.
Well, it could be 8 months prior to that.
Yeah. Well, yeah. Maybe not in October, but
maybe 2011, August 2011 or so.
Yeah.
So it'll jump back again.
I guess why can it jump that far? Because the dates have been that far before. A bunch of people in the last couple of years, Emily, if you're not aware, there has been due to COVID, there is massive extra employment-based visa availability over the last couple of years. EB3 dates were well beyond that. I think it was EB3 where it went to December 29th, or January 1st, 2015, I think it was. And people filed cases, got green cards, meaning if there aren't priority dates in that, if there aren't people waiting for green cards in that January to August 2009 to August 2012 window, there's space for the visa bulletin to jump.
Yeah. So just everybody to understand, the final action dates are dates set by regulations, by law. the State Department must publish these dates pursuant to certain rules to govern the number of cases approved, to be approved for the fiscal year, okay? Then sometime in the last 5 to 10 years, I now keep track, they invented the dates for filing, and that's purely policy. And the dates for filing is a future-looking date. We think within 7 to 8 months, the date is going to be on the dates for filing.
Yeah.
So allow you to prepare.
Yeah, basically the point of dates for filing are called dates for filing. It's saying, hey, file your case now because we think by the time that your case is ready to be approved and processed and you hand you a green card, that will be ready for that.
Yeah.
You know, it's designed to make the process more efficient so you get your green card the minute you're eligible.
Yeah.
You know?
So think of this here, right here, is the dates, the final action date. Think of this date here is the filing date, which is ahead in time. So the line is that way. So as the year progresses, that shrinks, get closer like this in their theory. And the theory is that the filing date will get very close to the final action date will get close to the dates for filing, and this will jump forward again the next year. So it moves this way, and then it moves that way every year. So it gets smaller, the window is smaller, and then by the end of the fiscal year, that date moves forward. So that gives you that dates for filing, give you a future look into what the final action is going to look like in theory. Now, USCIS completely rejected that, and they start playing games and they jump between the dates because based on their workload, blah, blah, blah. Yeah. The State Department and handling visas outside the U.S. are sticking to that policy and that system because they want people to file 6, 7, 8 months, a year in advance to be able to prepare the paperwork so they're documentarily qualified, if I say the word, when the visa is available.
It's a good idea to give people, you know, and say in the family, to prevent the visas from being wasted.
Why start when the visa is available? Why not approve when the visa is available?
It would seem to decrease the chances of the visas being wasted.
So that's basically what's going on between those two dates. Hopefully that gives Emily, Marshall some insight. Yeah. Scooby-Doo again for you, Brian.
Do you guys have any insight on 245K and how USCIS applies it? Just curious, but it could be a broad topic. So we've done entire presentations about INA 245K.
And there's all kind of policies and rules on that. So that's a big question, but the answer is yes, Scooby-Doo. And we've had probably, you know, it's a good, if you can ask a specific question, probably answer, because there's all kind of policy on how the dates are counted. You know, there's a lot going on.
I'll give an insight on INA 245K. Maybe what isn't what this individual is looking for, but it's kind of on the list of questions. You know, one of the questions we got was, you know, what kind of trends are you seeing in adjustment of status cases, pending green card cases? And one trend we've been seeing lately is USCIS asking about your detailed questions about your employment history and kind of lapses in it. And a scenario we saw recently was somebody went to a green card interview and they showed their resume to USCIS, and it showed basically, you know, this person was an IT consultant, and it showed their projects on it, right? And USCIS asked the question, well, what about between those projects? And what were you doing between then? And that raises all sorts of interesting questions, like, are you in compliance with your H1B status if you are, you know, between IT projects, and for how long? Obviously, it's good. You should still be paid by your employer, but what if you're not being productive? Are you still in compliance with your H1B status? How long do you have? Is there any sort of grace period between your IT consulting projects? And all of these eventually lead to, down the road, to INA 245K, which...
Potentially.
Yeah.
Because you don't have to be working productively as long as you're working. So working and working productively for me are two different things, and you do not have to meet the working productively standard. That's a standard of their figment of their imagination.
Oh yeah, the Department of Labor says, yeah, we're happy as long as you're getting paid. Yeah.
Well, no, you can go into training.
Yeah.
I mean, you can go into technology training. Let's say you have 6 weeks between jobs. Just don't go to the beach and hang out and do nothing. Contact your employer and say, I need to be in training. You're supposed to pay for my training, Mr. Employer. Give me give me something, because I want to be in status. I don't want to be challenged.
I'm not doing nothing when
I don't want to be challenged by USCIS saying that you really were not doing anything, although you're getting paid, because getting paid alone leaves you vulnerable a little bit. But if you're getting paid and also in training, you're refreshing your knowledge, nobody can touch you. You're untouchable.
I realize,
but digressing, 245K.
Yeah, committed the crime, not specifically talking about what INA 245K is.
Yes.
And state it very broadly, USCIS, when it comes to employment-based green card applications, they will excuse up to 180 days of status violations, unauthorized employment, and being unlawfully present, not having a valid I-94 since your last
working without authorization.
Yeah, working with it. Yeah.
That's the third one, right?
Yeah, working without authorization, violations of your status. So working, going outside your status, and
outside your I-94.
Outside your I-94, yeah.
So those three.
Since your last entrance to the
So
United
outside
States.
your status, meaning that you work in the wrong location.
Yeah.
You are on an F1, but worked.
Yeah.
That's the working without authorization. So violating the terms and conditions of your visa. So let's say you're on a B visa. And you began working 2 days before your H1B or something like that.
They can start asking about those things in the context of an I-40.
But I-245K is the rule. Also, there's no waiver form to complete. You just explain it. And the beauty about it, Brian, is that USCIS has to bring it up first by policy. So you don't have to you have to truthfully answer the adjustment questions. But if it didn't hit on that 245K issue, you leave it alone. And USCIS must ask the question before you answer, which is really good. Yeah. It kind of puts the burden on USCIS, which is a nice thing. But we can talk about this forever.
Yeah.
But Emily I think the dates will move in October, but USCIS data from March doesn't take into account the hundreds of perms and Department of Labor waiting approval. This means several hundred cases with earlier priority date to enter the queue. Yeah. Correct, Emily. Nobody really knows, but your intuition is right on in our opinion.
Yeah, I would also note that, the stinks, the perms are going slower. They're up to about 10 months to get it approved, labor certification approved right now, which is, it's
a long
pleasant.
time. Yeah. All right, Ram. Can I go for H1B stamping with employer A, followed by L1A stamping with employer B within 2 months? Will USCIS cancel without prejudice and revoke the H1B petition? If it canceled, can I use it in the future? Well, multiple questions, and they're really simple to answer. If you got an opportunity with an employer and you went for an H1B stamping and you found a better opportunity under an L1A with a different employer or the same employer, you can go back and request a new stamping. That's not a problem. I have absolutely no problem with that whatsoever. I found a better employer, better opportunity. I'm sticking to my foreign employer.
Now, I'll tell you this. I automatically favor the L1 stamping because it puts you in the path to an EB1 green card if somebody's willing to sponsor you for that inside the United States. There you go.
Good, good point. Excellent point. Yeah. Downside is you are
tied
to the employer, and now he has a stamping, but it's canceled. Does that undo? What does that do in terms of the whether is he cap subject or not?
That's one where I'd say there's probably a reasonable chance that USCIS if you go for another stamping, USCIS doesn't. They're not unless information is given to them. They're not going to cancel H1B petitions. They're not going to automatically withdraw H1B petitions on behalf of employers just because a stamping.
No, let's say a year or two from now, Ram is not happy with his L1A employer.
Yeah.
And wants to go on H1B. Can he use that H1B approval since it was approved and canceled? I would file transfers.
I would say that's probably with a new third company, I guess, or with employer A.
Employer A or employer C.
I would say you have some slight risks involved there, but it's probably worth taking.
Will USCIS cancel without prejudice and revoke the H1B petition? Well, they will not revoke the H1B petition, but they most likely cancel the H1B without prejudice. If canceled without prejudice, can I use it in the future? And that's the last question. You need to go back. The question is, it depends on if you're this becomes...
it's a 1,001 potential fact scenarios. If USCIS revokes the petition, that's a scenario where I have seen some pushback on whether or not you're counted under the cap. So
So we'll take the last question. from Ravi S. Do you have any, Brian, take it.
Okay. Do you have any insights as to how USCIS processes EAD and AP? It makes no logical sense for me to separate these two applications and not issue a combo card to everyone who applies for EAD and AP together.
Okay.
So historically, when I first started doing my job, well over a decade ago at this point, they weren't issuing combo cards. And then one day they said, hey, combo cards. Why aren't they doing it now as of late? Because EADs and APs have different requirements, right? And they say it takes them longer time to process an AP because they're basically trying to make sure it's safe for you to travel. As I understand their processing of an AP. Basically, will you be able to come back to the United States, right?
Yeah.
Yeah, and that's really kind of the difference for me.
So, yes, it's kind of confirmed. It's all about how to save money because they're for free. The dilemma they have is that they're not collecting money on them. So they're just kind of trying to find a way to do this in a cost-effective way. And that's really the biggest mistake they did not collect fees. Because if they're collecting fees, they'll do it the way you like. They'll probably combine them and they'll probably do them faster. Yeah. All that is because they're not collecting money on them. They spend the money on the adjustment and then, oh, I got to deal with this EAD and advanced parole. How can I do it the cheapest way? So they combine them. Yeah. And then when they combine them, they run into a problem because they start getting backlogged because of COVID and other problems, and they get buried under mountains of work. Yeah. And when they get buried under mountains of work, the EADs were not getting done because the APs are more complicated. And therefore, now they separated them. It's a mess.
Yeah. Yeah, this makes me really want to look at the books for USCIS. Like, where does the money go? Because
it's waste, government waste. I mean, government is not efficient.
Yeah, that's
the bottom line. With that, we end today's presentation. Hopefully, it was helpful, guys. Give us your feedback whether you like the full hour Q&A every now and then.
We read the comments. Yeah.
And we appreciate your time. You guys have